we can get started in the next couple of minutes. But
will Tony and I be the only ones on video?
no, I'm also going to be on video, and Marianne as well will also be on video, and Roy will also be on video. I am just organizing all my reference tools. So I will be on video in just a minute.
No problem. Just wondering.
I should have gone and fixed my hair.
I always look yeah. I always look at the image and I'm going, what? Should have fixed the hair.
Mom, when did you get here?
I hear you.
So it is 5:31, and I was curious if you would like to get started, Deputy Mayor and Councilmember Lyons, or would you like to give a few more minutes for people to sign in? It does look like we have 49 attendees, so I know we have 156 signed up, but we could get started if you would like.
Okay, thank you. And I appreciate everybody joining us tonight. I know this is a subject that has, become quite the issue, and City Council deals with controversial issues every once in a while, and this has definitely developed into one of those. So we are working hard to come up with solutions that will balance the interests of the community. And so we have worked with staff to get to the point where we're making this presentation tonight. I would like to emphasize that this subcommittee meeting is intended to receive feedback from the community, but we're not going to be making any final decisions. Obviously, we're going to be moving this issue to the full City Council, and we will make recommendations, but ultimately it will be decided by the full City Council and not tonight. So again, I thank you all for participating and for all the input that you've provided so far. And with that, I will introduce Joy Lyons, who is joined as a member of this subcommittee and has jumped in head first. And thanks for all your efforts, Joy.
Thank you, Deputy Mayor Kranz. Just as a brief introduction, I am representing District 3. And when Council Member Hinsey needed to step out due to a conflict of interest on this matter, I was invited to participate with Deputy Mayor Kranz. And I've had the opportunity to take phone calls from many constituents with Deputy Mayor Kranz on this item. And we've gotten a lot of great input so far. We're looking forward to hearing your thoughts and answering questions. And if you have comments, just comments. Feel free to just give comments. If you have questions, ask questions. And this is a great opportunity to hear from a broader group of folks. So with that, we'll get right to it because that's the main reason we're here. And the input we hear today will help us to bring forward this draft. This draft is for our meeting today for our dialogue on this topic. So don't look at it in terms of this is a set thing. It's not, but this is our draft and we're using it to get your feedback, and your feedback will be considered as we develop it further. And with that, I'll hand it off to our staff. Thank you.
Thank you so much, Deputy Mayor and Councilmember Lyons. My name is Lillian Doherty. I'm the Director of Development Services. Here with me today, I have Assistant Director Royce Powell, Marian Bushimi, Code Enforcement Supervisor Dina Gay, Kathy Noel, and Anne-Marie Clisby as our support staff as we move forward in collecting community comments and feedback regarding this important topic. We appreciate the community's widespread interest in this topic and appreciate your participation this evening as we work through this challenging issue. Next slide, please. So this evening, we will cover, as you heard, the opening remarks of the Deputy Mayor and Councilmember Lyons. We will discuss the existing program, identify the issues and concerns that have brought this issue to bear, and provide our proposed recommendations that we would like to solicit input and feedback this evening, which is a three-pronged approach. And then we will open the floor for question and answer. Next slide, please. So the existing program, some may ask, what is a short-term rental? In our city, we define a short-term rental as a rental of a residential dwelling unit of a period less than 30 days. We have approximately 349 permitted rental units within the city. In addition to those, we have identified 70 unpermitted rental units. And you will hear later this evening how city staff and our consultant are seeking to bring those units into compliance. 6 of those actually have an application with the city and would be issued a permit, assuming there are no issues. However, they are under review, so I don't want to be predecisional. This evening, the question before us is, what problem are we trying to solve? Next slide, please, Karen. So this is a very challenging issue because there are 2 very different sides of the coin. We have a number of neighbors that have identified things like noise and disruption, parking congestion, and a disruption of their residential communities, a reduction of available housing stock. And that goes in contrast to residents that have identified that they are dependent on this income, that they've been successful in the implementation of their short-term rental. They've not had any complaints. And that this program, the reason that we're here this evening is essentially because there are a few bad actors that really need to be brought into compliance. And that any discussion this evening might be considered punitive on their side. So we just want to acknowledge that there are two very different competing interests that we are trying to balance. Taking these thoughts into consideration, we have developed a 3-prong approach that we are hoping to discuss this evening. The first being the question of enforcement. And what we've heard time and time again is this idea that, we have this ordinance in place, the municipal code is in place, all you need to do is enforce it, and then everything will be resolved. I'd like to turn it over to Marianne, however, because she is the front line of trying to enforce these ordinances, and it's not as straightforward as it might seem. So I think she can bring some additional context to the community as we go through this question of enforcement. Marianne?
Good evening. I'm Marianne. I'm the City of Encinitas Code Enforcement Supervisor. Yes, as Lillian was saying, it's not as straightforward as it sounds. We do get an awful lot of complaint about lack of best efforts, is what our short-term rental regulations call it, and that would be noises, parties, what was shown in the previous slide. What we are looking at, because code enforcement staff does not work at nights or on the weekends, and we're limited, we are looking at initiating a pilot program where we will get additional coverage on nights and weekends. Our intent would be to have the additional personnel actually patrol the areas where we have gotten the bulk of our complaints from lack of best efforts. That way they can hear it for themselves. We will take written complaints. To open up a case, we do need to have, according to the municipal code 1.08.085, we will need a written complaint signed under penalty of perjury that there's disturbances going on. What really helps the code enforcement department is to have any event or incident report numbers from the sheriff's department so that we can initiate the fining program, which we have done quite a bit in the past. But we are hopeful that the additional coverage on the night and the weekends and the additional patrols of the corridors will be a helpful solution to some of the lack of best efforts in the city.
Thank you, Marianne. So the next prong of our approach would be to scrutinize our code and to assess changes that we felt would address some of the challenges that we've seen in terms of our operations. While this is an illustrative list, it's not a comprehensive list of what we are considering. But these are the ones that we believe have come to our attention as things that we do need to revisit. So the question of minimum night stay, to avoid large groups coming in and just throwing large parties, we felt that a minimum night stay of 3 nights would be something that would help ensure that we have visitors that are coming and are a little more invested in a quiet residential type stay, ensuring that we are implementing safe practices, such as prohibiting camping and bonfires, to ensure that we don't have any open fires or any concerns that would arise from those types of behaviors, given that residential areas are not typically suited for camping. We have looked at the fines. One of the things that we have identified is that the current fines in place are very low compared to what short-term rentals are making per night. And so just looking at that, the economic benefit is so high to continue, and our penalties are so low that we've seen that the penalties we currently have in place are not as effective. So we've looked at a minimum fine of $1,000 or the greater of $1,000 or 1 advertised daily rental rate. We've also looked at reducing the number of violations that would need to occur within a 24-month period, from 4 violations to 3 violations. It is a challenge to reach that 4 violation number, whereas we continue to see violations in place. As Marianne mentioned, we do need to have a written complaint, a signed complaint, or a sheriff's report. And the reason for that is because we have to, there is a requirement that we're able to support the violation. And so as staff, we need to be balanced in our administration of the program, and ensuring that we have good, solid evidence is key. Additionally, we are proposing if a permit is revoked, a 1-year suspension period prior to reapplication of a permit. And we've seen this in other cities, and so we are proposing that as well. Finally, we are including a program fee, which would help in the administration of the program and would help support the reviews, our consultant costs, as well as ensuring that we are following up on concerns and complaints. So those are a number of the code changes and modifications that we are looking at. There are others, however, and we are happy to, as we mentioned, take those as part of comments and continue to look at opportunities where we can potentially do better. Next slide, please. The third prong is an adoption of a good neighbor policy. And the purpose of a policy would be to create general guidelines that are in line with this idea that we want to ensure that short-term rentals are courteous to their neighbors and respectful and in line with residential type behaviors in what someone would expect when they are living in a community. What we've heard in the past is that sometimes visitors are not considerate of the residential character in which they are staying. We've heard things like, that a short-term rental is different than a hotel, and we want to acknowledge that. And a hotel is often in a different part of the city because of the that type of nature. And so ensuring that we are respectful of the area where these short-term rentals are located, things like ensuring that there's no unreasonably loud music, that trash is not visible, and that we are parking in accordance with all posted parking regulations. And there are some parts of the policy that are just echoed in our Encinitas municipal code, such as no oversized vehicles parked on streets between 10 p.m. and 6 a.m. But just being able to have a one-page document that sort of puts together all of these sort of good neighbor guidelines that would be easy to perhaps include and display in some of the short-term vacation rental units. In addition, this is a requirement as it stands, but ensuring that we reiterate and emphasize that neighbors have access to a 24/7 contact number where they may call to file a complaint. And that is, again, a requirement that is already in place, but just reiterating that in a single location, a single sheet, that is a courtesy reminder to visitors that these resources are available is something that we are also contemplating. With that, Karen, next slide, please. So I am about to open up the floor to the purpose of today's meeting, which is essentially that we want to take as many community comments as, and questions that we can. But some general guidelines before I do that is that our goal tonight is to read first from the chat box, and then we will then, once those are completed, move to the submitted comments that were submitted in advance. The question and answer period, our meeting tonight, the expectation is that we will conclude at 7 p.m. and to be respectful of participants' time, we will conclude at that hour. I want to assure everyone that is participating this evening that any questions that are not responded to will be included in a report with a response within 2 weeks that will be published on our website and shared via our constant contact list, and also available upon request and on our website. The recording this evening of this meeting will also be shared through the contact list and also available on our website. And it will be available by the end of the week. So we are trying to provide all of the information in as many mediums as we are able to. And so I just want to assure everyone that we are looking to collect as many comments as we can. So with that, I would like to, next slide, please, open up the floor for any questions. But, oh, and I apologize, Ray, just one more comment. So if there are any comments that you would like to submit, either because you don't want to include it in the chat box, or perhaps because you'd like some additional time, please email aclisby@encinitasca.gov, and we'll be collecting those comments at that email address. Again, at the conclusion, even after the conclusion of tonight's meeting. So with that, Roy, I'd like to turn it over to you.
All right. So far, we have 8 questions in the chat room. So I will start with the first question. This is from Rick Smith. The question is, can we or will we receive a copy of the slide presentation?
We are happy to post a copy of the presentation online at the conclusion of the meeting.
Okay. Next question is from Crystal Dirks. How much is the program fee?
At this time, we have not determined a cost of the program fee. That's still in discussion as we try to better assess what potential changes would be needed to the program.
Okay. Next question is also related to the program fee. Is program fee retroactive, and how much are you proposing the fee be?
It would not be retroactive. However, again, as I mentioned, this is still a topic that's under discussion and consideration as we assess the changes that would be made to the program.
See, next question is from Nayar Sadiq. I don't see anything about properties with common area. I have part of my property rented without my consent. That was a comment.
Okay. Thank you for that comment.
Okay. Next question is from.
Oh, well, let me go back to Nayar's question and comment, the issue of duplexes and the requirement that both property owners are part of the permitting process. We do have some language in the proposed draft that addresses that, do we not?
So we are in discussion about having some approvals or awareness from all property owners. However, we do need to look more closely at that, given that there are, we need to determine how to frame that requirement. So we are looking at that. Yes, Tony.
And if I could just add on to what Tony just asked, I think NIAR is specifically mentioning common area here, shared common area. So it's not just attached or duplexes. That's how I understand that comment to us. And still the same answer, I think, Lillian, that we're assessing it and trying to figure out how to capture that requirement in the draft.
That is correct. Yes.
Okay.
Thank you.
Okay. Next question from Crystal Dirks. How do these proposed revisions apply to owner on-site vacation rentals?
At this time, the proposed changes would not distinguish between owner on-site versus a managed site where the owner is located off-site.
Then a follow-up question from Crystal Dirks. Also, you didn't mention the occupancy tax being collected through the platforms, Airbnb and VRBO. Is that still being considered?
That is still being considered. Thank you for that, Crystal. TOT is a requirement of all operators. However, to streamline the collection, we are discussing the potential where the platforms could then just collect the TOT and remit that payment directly to the city, just because it's both simpler in terms of the administration, and it would, ensure that TOT is collected on each stay that is booked on the platform.
And Lillian, if I could add in response to Crystal's question, one of the things that's important to us as a city is to make sure we track the receipt of the TOT. And so that's one of the things that we are assessing, is how we would track it when the entities are collecting it for us. So I just want to kind of emphasize that tracking who's paid is important to us. And so we want to make sure we've got that T crossed, I dotted, as far as we know who is paying and who has paid.
And following up on that, even if the platforms collect the tax, it's unlikely to relieve the responsibility of each property owner and permittee to file their quarterly reports that identify the revenue that they generated and what their tax amount is. And so there will still be that requirement, but we probably have to revise our form to indicate, that Airbnb or VRBO collected that money for you and remitted on your behalf as part of their monthly payment. So again, I want to make it clear that the requirement to complete the quarterly report for short-term rentals would not go away. So the reporting requirement will still be there.
Okay. Next question is from Nagam Rao. Is the STR permit applicable to the address or the property owner of the property?
So it would be applicable to the property owner of the property. So for example, if the So for example, should a property owner have their permit revoked, if they were to sell that property and a new property owner sought to secure a short-term rental, that owner, at least how we envision it currently, would be able to apply for a short-term rental permit at that time as a new owner. Sorry, I just wanted to make sure I was clear.
All right, next question from from Nagam Rao. Do you currently allow RVs or oversized vehicles to park overnight on city streets?
We do not. The Encinitas Municipal Code has an explicit restriction that RVs should not be parked from 10 p.m. to 6 a.m. Is that right, Marianne? I believe I got that right.
Nope, that's absolutely right.
Okay.
See. Next question is from Seth Grossman. Is the anticipation that this will be passed in the near term? If so, how long will it take to receive a new permit?
So at this time, we are collecting feedback and inputs. Our goal would be to implement our pilot as quickly as possible, particularly in acknowledgement of the summer months that come. However, with respect to the ordinance, we have not developed a timeline on that at this time.
And then a follow-up from Seth. Is there a limit for the number of new permits that will be granted?
There is no limit at this time. Roy, I just want to verify that there's no limit in terms of the number of permits that we would process.
That is correct.
Okay.
And then a comment was made from a follow-up comment from Seth that we had requested a permit years ago through the appropriate channel, but were told then that no more permits were being granted at that time.
So I apologize, Seth. I'm not sure how that messaging came to you. If this is a program that you are interested in participating in, I would encourage you to apply. If you would like to email Anne-Marie, we can certainly put you into contact with our planning department that could help with that, as well as if you would like, you can email planning@encinitasca.gov and they can also similarly direct you. And then also, I apologize, we also have our customer self-service center, which you can sign up for on the city website and also apply through that process as well.
Right. Next question is from Richard Kipnis. Will you consider making separate regulations for owner-occupied short-term rentals versus whole house rentals?
We have talked about that. It has been something that we discussed, and Lillian, Roy, I'm not aware that it's in this draft though.
I think we can certainly consider it, and we welcome a better understanding from the public if this is something that the public would be interested in seeing as we move forward with the changes to the ordinance.
Okay. Next question is from Carolyn Winship. Would the proposed rules hold renters to a higher standard than homeowners?
I'm assuming we mean the short-term rental individuals. So I don't see this as holding the renters to a higher standard. I think that the Encinitas Municipal Code does limit RVs. It does not distinguish between short-term vacation rentals or residential units. There is an ordinance, a noise ordinance that applies. Code enforcement would enforce the requirements of our nuisance ordinance, regardless of whether it's a renter or a resident. However, there would be, I believe that the operational conditions are intended to create additional guidelines for how renters are able to utilize a unit. So again, minimum night stay, and to the extent that permittees are not enforcing good neighbor guidelines and the nuisance requirements with their own renters, there would be, as I mentioned, higher penalties. Joy, it looks like, do you have something you would like to add? I just want to make sure that
Yeah, I didn't have anything to add. I was thinking, do I have my hand up? I just had a look on my face. I'm sorry.
I just wanted to make sure I gave you that opportunity.
Okay. Yeah, and I guess my look is I'm not quite sure I understand the question, but if Carolyn Winship feels that wasn't the right answer, please ask another question. Maybe we'll understand it better.
Okay. Next question is from Crystal Dirks. I believe in the email, it was also mentioned limitations on how many days a year rentals could be rented. Is that still being considered?
That is not something that I had considered explicitly. If the council members would like to consider that, I'm happy to do so, but it is not something currently that we've looked at.
Okay. Next question is from Warren Goldberg. I assume hosted short-term rentals are rarely an issue since the host lives on property. Can you eliminate the 3-day minimum for hosted rentals based on this?
So I think we can certainly consider it. I think since the comment has been made that hosted rentals versus whole house rentals be considered separately, I think certainly we can look at that as we move forward.
Okay. Next question is from Rory Riviere. Would our city be using TOT to have a specific employee to go after the bad apple owner/manager?
Currently, TOT is collected and returned to the general fund. I believe what we are currently proposing is looking at a program fee that would enable us to have more resources to administer the program overall.
Okay. Next question is from Jordan Stockham. As we see at the Olympus Park, parking and off hours are not enforced. How will a pilot program be beneficial beyond what we already know?
So I think having a pilot program that is available after hours and on weekends is something that would very much benefit the program, because most of the complaints occur in the night hours, disturbing people's sleep, parties later in the evening, and then on the weekends when there are oftentimes when visitors want to come to our city to enjoy all the resources that we have here. So having additional support staff that are available to enforce a number of different ordinances, not just short-term rental, but also things like parking, alcohol-related ordinances, all of those things, having that pilot program in place would really help support the city's enforcement efforts. Joy? Yes.
No, Mary Ann, please go ahead, because I think I'm getting to something you're going to say.
No, I was going to say what's going to be beneficial with the support staff would be particularly knowing where to go on the weekends. In what area, what cluster are they at, what area of town. In addition, I don't think I brought it up, but we would also be proposing having a hotline for people to call into the city, if possible, to let us know about the lack of best efforts. So once again, we'd be able to narrow it down, because there's a few areas where it gets a little bit more wild than other areas.
Yeah, thank you. I was just going to ask you to shed some light on that.
I would emphasize that historically in code enforcement in the city of Encinitas, the program is essentially a reactive program based upon complaints filed under penalty of perjury, et cetera. And that what we're proposing as this pilot program is a much more proactive, where our code enforcement officer is actually out on the streets during the hours that the issues are most likely to arise. So this is a shift in how the city does business in this realm. So that's why it's a pretty important pilot program. And we are, working to address the issues at Olympus Park. So I see the shot, about what's going on over there. But there again, we're addressing a wildly successful park. And yes, there have been some problems that have developed, but the Parks and Rec staff is working with the Sheriff's Department to address them as quickly as possible.
Next question is from Cliff Keller. How do you define and enforce the term unreasonably loud music?
Marianne, could I refer to you?
Sure. We, in our municipal code, it pretty much mimics what the sheriff's departments do for disturbance of the peace. It would be anything that affects anybody of normal and reasonable sensibilities. So the sheriff's department actually goes out on these disturbance of the peace calls, and they do make the judgment.
Thank you, Marianne.
Next question is from an anonymous attendee. Is the program fee one time or yearly?
Presently, as we are formulating it, the program fee would be part of the renewal of the permit.
Next question is from Joel Munoz. Are twin homes considered condominiums as per the municipal code regarding short-term rentals? And if so, are whole home rentals banned for condominiums?
So Roy, I'm going to turn that one over to you.
Right. As far as twin homes, those are considered attached single family. Each unit is on its own individual lot, so therefore it's considered a single family and not a condominium. So, then the next question says, and if so, are whole home rentals banned for condominiums? So the issue with condominiums, those are considered airspace, creating airspace of form of ownership. Condominiums could range from 2 units to upwards, however, anything over two units on one single lot. So duplexes are 2 units per lot. And duplex could also be condominiums. And our short-term rental ordinance allows short-term rentals or duplexes to use short-term rentals. But anything over that, short-term rentals will be prohibited. Okay. Next question is from Roz Mensanelli. What about non-owner occupied short-term rentals? These are the ones that seem to cause the most problems as the owners are not residing in the neighborhood. I don't see this addressed here at all.
So as we have previously mentioned, we will look at separate treatment of partial home versus whole house. However, one of the things that we were planning to include is ensuring that there is a local point of contact, meaning within the County of San Diego, that is available, as we mentioned, on a 24-hour basis to respond to concerns or complaints, ensuring that there is a local point of contact that can respond to concerns. As we evolve, it may be that we make some additional changes based on whole home versus resident occupied.
Next question is also from an anonymous attendee. Can you help me understand the concern with oversized vehicles parked on streets between 10 p.m. and 6 a.m. per EMC? There are large surf van, sprinter vans parked all over Cardiff all the time and overnight, which I have zero concern with. Will you now be enforcing this for all streets/houses or just those that are used as short-term rentals?
So Marianne, I'm going to refer this to you. However, I do just want to make the point that the Encinitas Municipal Code does not distinguish between short-term rental versus other residences. So Marianne?
You're correct. The Encinitas Municipal Code 1441-45 defines a recreational vehicle as a trailer, camper trailer, boat trailer, campover, camper truck, motorhome, or similar vehicle. Also vans or van conversions being used for habitation or camping purposes shall be subject to the provisions of this chapter. This is a city-wide regulation and it's enforceable through the Sheriff's Department. The Sheriff's Department will at times go out and cite on what they see. However, sometimes people do call in to let the city and the Sheriff's Department know that these recreational vehicles are being parked overnight. The problem is they do take up an awful lot of space at night, particularly when people come home from work, when everybody comes home and there's no space on the street. So people do get upset when they see a lot of the recreational vehicles on the street.
Okay. Next question is from William Burton. Will City of Encinitas noise ordinances be part of the good neighbor information given to renters and supported by code enforcement? It's any kind of noise, not just loud music.
Yes, so I believe that would be more comprehensive. So the PowerPoint was intended to provide some of the information that we plan to include, but not intended to be comprehensive. So just to clarify, the goal would be to ensure that all loud noise, not just loud music, would be considered as part of the good neighbor policy.
Next question is from Keith Clark. I have been licensed to offer short-term rentals since 2015. I would like to have the ability to offer 2-night stays from time to time. I generally rent a minimum of 3-night stays as the standard, but would like to be able to offer 2-night stays to fill in gaps. I probably have had a total of 5 to 10 times offered a 2-night stay to fill in my high season days like July. Is there a way to handle this as an exception to the rule?
So we appreciate that comment. I think it's something we can certainly consider. Again, the purpose of this evening is to take public comment and suggestions, and so that we can better shape and inform our process as we move forward to something that we would eventually present to City Council.
Okay. Let's see. Next question is from Roz Mancinelli. Also, you mentioned 3 violations in a 24-month period. Could you consider police to make it within a 12-month period?
So again, I think that's a very reasonable comment. I think we can certainly consider it in light of other comments that we receive, and we will certainly consider this one as we look to shape our ordinance moving forward.
Okay. Next question is from Craig Benedetto. Following up on the duplex comment, when will a comprehensive list of ordinance changes be provided? This is a more substantive point. Are there others?
So the goal would be to take public feedback, and once we are able to digest the public feedback that we've received, we would make additional changes to the to what we have in draft form at this time. And then we would be able to come up with a date certain that we'd be able to present it and agendize it for City Council consideration. However, at this time, given that we are in the initial stages of seeking public input and feedback, we don't have a timetable for when that would be agendized.
Next question is from Maria Greenwald. Will you have further separate STVR regulations for non-owner occupied? The pension fund and investment groups are buying up properties and are not neighbors. This is a group being banned in many cities. We have proposed more restrictions on non-owner occupied property in change.org, and this has been signed by 173 real neighbors.
Yes, so I do want to acknowledge that we have received a copy of the change.org petition. We have looked, and I have actually submitted the proposed changes that were in that petition for consideration by our team. And so we will be looking at not only the changes that you've recommended, but also the other ones included in the petition. So I just want to confirm that absolutely we will consider these comments. And I want to, again, acknowledge that we've seen the petition, we are aware of the proposed changes in it, and we are considering those changes as part of our, as part of the input that we're looking to make changes to the ordinance.
Next question is from William Hildreth. What is the benefit of the 3-day minimum stay? As an owner, I host one-night rentals only to provide my cleaning help with employment.
So what we've seen is when there is a single night stay, time and time again, there will be large groups that come in for party or party-like purposes, and they're often the most disruptive renters. And what we've seen in other cities, not just ours, is a minimum night stay and sort of precludes that type of disruptive behavior. It discourages disruptive behavior because there's a little bit more of an investment in the community if you want to stay 2 or 3 nights. That renters will come in, they'll be a little more respectful. They try to keep the property a little bit cleaner. They'll make a little bit less noise because, to be quite frank, they don't want to lose the opportunity to stay for the full period that they reserved. So I think there's a lot of benefit to a minimum night stay.
Next question is from Renee Labar. Will there be a limit to the number of STR allowed in the city? And if so, will there be priority for those operators who have been paying occupancy taxes and fees without any complaints?
Presently, we have not included a limitation on the number of short-term rentals within the city. To be very candid, I think that could be a challenge with Coastal Commission if we attempted to try to limit the number of short-term rentals within the city, particularly in the coastal zone, where we do see the largest number of short-term rentals in our city.
Next comment is from Rick Kremen. Would you consider tying the number of guests to the size of the unit? We only rent to 2 people, even though we are allowed to have 3 guests. As a result, we often get couples who come for the weekend for 2 nights. Limiting us to 3 nights would change our clientele. We are owner on-site rental and have had 0 problems.
So I appreciate that feedback. I think that is helpful feedback to help us understand how short-term rentals operate and to distinguish owner-occupied versus whole home occupied. So we will certainly take that comment and consider it as we move forward in the shaping of our ordinance.
Next comment is from Jordan Stockham. How is there a single scenario in which homeowners won't have to be involved for enforcement, meaning have to file complaints?
I am, can you read that one more time, Roy? I'm struggling to understand the comment or the question.
It says, how is there a single scenario in which homeowners won't have to be involved for enforcement?
And my expectation is that the homeowner, which is also the applicant, would have to be involved. I think I understand that.
Yeah, his question gets to the heart of the whole issue, is that, you know, the neighbors of short-term vacation rental properties, you know, are off put just by having to file a complaint or make a phone call to any hotlines or the number that's on the permit in front of the house. It's the desire of Jordan and many people like him that live nearby these units to not have to have their peace disturbed to the point where they have to make a complaint. So that is indeed the balance that we're trying to get to, is have good neighbor policies that make it very rare that somebody would have to file a complaint. That's the goal. And I would just acknowledge Jordan's point and say, this is indeed the thing that we're trying to address, and finding the balance and getting to life where, you know, you don't have to make a phone call because a short-term renter is next door raising hell is definitely our objective.
And key to that is proactive enforcement that Mary Ann overviewed earlier.
Next question is from Susan Singer. How would the 3-night minimum be enforced? My usual minimum is 4 nights, but occasionally I end up with a 2-day window. Also, would it be possible to require the 3-night minimum to include Saturday and Sunday?
So the enforcement, we do have a consultant that monitors platforms and advertisements. We would be spot checking and auditing the platforms to ensure that within city limits, the minimum night stay, if that were to go forward, would be 3 nights. Similarly, we would, you know, expect that our permittees would be upholding a 3-night minimum if that is the requirement that is in place. A failure to include a 3-night minimum would mean that that permittee would be exposed to a potential violation of our operating standards and guidelines and within the code. And so I believe that would be the enforcement. I think there was a second part to that question, Roy. I'm trying to make sure that I answer all of the parts of the question. Oh, sorry, you're on mute.
The second half of that question is also, would it be possible to require the 3-night minimum to include Saturday and Sunday?
Yes, so I don't think there would be any distinguishing factor between the nights of the week. So Saturday, Sunday, Monday, Friday, Saturday, Sunday. I believe that all of those things would be included unless I misinterpreted the question.
Next question is from Carrie Smith. Why should short-term rentals be singled out for extra taxation, parentheses, program fees, and extra regulations than neighbors, i.e. loud music, good neighbor?
I think the answer to this is that we are not singling out short-term vacation rentals. In general, there is an Encinitas municipal code that applies across the board to uses within residential areas. What we are looking at is a closer review of the short-term rental program, to be very candid, because the city has received quite a few concerns from the residents that live next door to the short-term rentals. Yes, it's absolutely true that there are good actors that have not had any issues for many, many years. But in that same vein, those same actors shouldn't have any concerns moving forward. I understand that there's a concern about the program fee, but you know, that is something that we are considering. It's not been set in stone, and so we welcome the comments. And I think that we can consider that. And the goal would not be to have such a high or prohibitive program fee, but just something that would ensure we have the resources to properly administer the program. Tony, it looks like you came off mute. Did you have a comment?
Yeah, I just was going to point out that like any permit fee that we charge for evaluation of an application, there needs to be a nexus between the work that's being done in order to consider that and the fee that is charged. So this is not any punitive measure against people that are interested in being a short-term rental permittee, and nor are any of the regulations related to nuisance activities. These are, I have had the sheriff show up for parties at my house and had to tell the band they had to go home. It's not uncommon for situations in neighborhoods to, generate into nuisance, and there are disputes between neighbors who aren't short-term rental property owners. So I think that the distinction is that we're trying to make sure that the people that are renting the facilities have acknowledged through the good neighbor policy that they are expected to behave in a way that is conducive to single-family neighborhood living. So I just want to make sure that we emphasize that point.
Thank you,
Okay.
Tony.
Next question is from Roz Mancinelli. What about increased HEFI fines for those operating without a permit? In parentheses, $5,000 fine.
So I am going to mention that I think I've seen at least one other comment of a similar vein, and we are happy to consider that as we move forward. And I am not sure. I think it's a very a good point to ensure that we have perhaps a separate penalty schedule for those that are operating without a permit. However, we would need additional consideration about what those fees would be what those penalties would be at this time.
And aren't there state laws that implicate this particular issue, and the city attorney needs to kind of evaluate this? We can't set our own gnarly fees or fines, can we? Isn't there some sort of state law that keeps that from happening?
So I would like to consult with our city attorney on
Okay.
that particular point.
Next question is from Kathleen Lees. Are there any requirements for notifying neighbors?
So, and Marianne, correct me if I'm wrong, but my understanding is that when a short-term rental is in operation, bearing in mind we've seen instances where a short-term rental is permitted, but it's not operational. The short-term rental unit is required to include a visible sign with a phone number notifying, by which residents could call 24 hours every day. And so that would be required to be displayed when the short-term rental is in operation. I just want to really emphasize this point because, a resident or a homeowner could have a short-term rental, but it doesn't mean that it's always being used in that manner or fashion. Marianne, go ahead.
Yes, in addition to posting it outside at the time that permits are obtained, they are required to notify all adjacent property owners and to give the adjacent property owners the 24-hour number for them to contact the property manager or themselves in the event that there's loud noises and parties and things like that. So yes, there are requirements for notifying the neighbors, adjacent neighbors.
Oh, sorry, Roy.
Next comment is from Randy Boyer. We already pay a yearly license fee and added tax based on our yearly rental. I don't see a need for a new fee or the limitation of 3 nights. If you have issues with specific addresses, you should deal with those properties directly. We manage an on-site rental without issue. Next comment is from Crystal Dirks. I think collecting TOT taxes via the platforms would help identify any non-permitted properties.
I would like to comment on that particular point. we have had conversations with both Airbnb and VRBO, which is an Expedia company, and both of them remit TOT to the city without any identification of who the money is from. So it is one of the issues that complicates, in some ways, the collection of TOT. You get a check and you don't really know which properties the monies are associated with, which is why it's a requirement to still file your quarterly reports that identify the revenue stream and calculate the TOT. So the answer to that is that the platforms do not identify the parcels that the revenue is associated with.
All right. Next comment is, or question is from Jordan Stockham. How would fines after the infraction help the homeowners directly affected who had to get involved in order for there to be a fine?
So the expectation is that the fine would be intended to discourage the behaviors that have upset the neighbors. Our hope is that through the changes that we're making in the ordinance, that we would see changes in behavior of the renters, that we would see more best efforts on behalf of the renters through the additional education and the efforts of this program. The goal would be that overall our communities would benefit, because we're hopeful that we're going to have fewer complaints moving forward. And if the fines are of an appropriate level, then the anticipation is that the behavior that caused the complaint would be reduced in the future. So that would ultimately be the goal.
Next question is from William Burton. Will the city also start performing safety inspections, particularly for rental properties with pools, prior to issuing STVR permit? For instance, making sure there are self-closing gates to the yard and pool safety equipment and signage.
Roy, I thought that was already part of the application process.
In terms of ensuring that the building, so when they receive building permits, that there is a follow-up inspection. But this question is pertaining to when they file a short-term rental application, will we staff conduct inspections to ensure that if there's a pool, that they're meeting all the safety standards?
So I think the answer to that is that with respect to safety standards, each homeowner is liable for any behavior that occurs on their property. The city does ensure to the extent that we're able to, that homeowners do comply with our building codes. And we do enforce those separately, regardless of whether it's a short-term vacation rental or it's another rental unit. That's a common focus of Mary Ann's work. So I think the answer is that so I think what I'm hearing in the question is that would there be a separate inspection? I don't believe that would be the case. To be very honest, we as a city staff don't have those kind of resources to have inspections every time somebody receives a permit. And so we do expect that property owners take sufficient precautions to ensure that their homes are safe, especially if they are inviting guests or renters onto their property.
Next question is from Roz Mancinelli. How about limiting the number of guests allowed at any property to keep party home situations from happening?
So I do want to clarify that point. Our ordinance already indicates that there is a limitation. So with respect to the number of bedrooms, it's 2 people per bedroom plus an additional 2 guests. So it is dependent on the number of bedrooms, bedroom as defined in our Encinitas Municipal Code. And so there is a limit on the number of guests, depending on the number of bedrooms.
Next comment is from an anonymous attendee. I think it is a mistake to not differentiate between hosted and non-hosted rentals. Data from other areas clearly show that the problems from short-term rentals is from non-hosted rentals. Why not differentiate?
Okay, thank you for that comment.
Next comment is from.
I would like to point out that one of the challenges of that is the issue of follow-up to determine who is truly owner occupied or not. And so it presents a significant challenge. I think that, you know, for those properties that are being rented that are owner occupied and there are no disruptions and they are good neighbors and successful, they will not be visited by the city. And you know, those properties that are not owner occupied and are having unruly guests are more likely to see the city because of that. But to try and make that distinction up front is a very difficult challenge, something, you know, that would create a management issue. But I understand the comment, and it would be nice to be able to make that distinction. It's just not something that is easily policed.
And if I could just ask also to staff, when on the permit application, do we ask the question if the owner resides at the residence at the short-term rental? We can help ourselves maybe a little by doing that if we don't already.
Roy?
Yes, we did.
We do ask it. And so Tony, your point is it's hard to enforce. We do ask it, but it's hard to enforce.
Yeah, and you know, so there are ways that you can tell from the public records if the property is owned by a LLC and their address is in you know, Reno, Nevada, then it's you know, pretty likely that that particular home is not owner occupied, and therefore any short-term rental permit is not owner occupied. But it just would open this thing up for being gamed. And so I think that for me, the goal should be to essentially get you know, the STR properties kind of into the same program and manage them from the city standpoint the same way. Are you creating a nuisance? Are your guests creating a nuisance?
Next question from Sabrina. Will there be any limitations on full home rentals like in San Diego?
Presently, we're not, I think just referring back to Tony's comments, we would be looking holistically at the program and making whatever changes we deem fit based on the input and comments that we've received at this time. I don't know that we've looked at specific restrictions on whole house rentals because again, we're looking at a program that would apply presently to both operating statuses.
This next question is a follow-up from an earlier question. This is from Carrie Smith. Why should extra reporting be required if TOT fee are being collected through platforms?
So Roy, correct me if I'm wrong, but I believe it's not extra reporting. It's a requirement of the program currently. And I think as Tony explained, that the platforms don't distinguish between the rentals. So it is up to the individual owners to basically report what their tax liability is. And then, you know, potentially we would look at some kind of certification that it was paid through one of the platforms. And it's also possible that the short-term rental was rented outside of a platform, in which TOT would then be required to be remitted at that time separately outside of the platform.
Next question is from Susan Singer. With regards to complaints, can there be a requirement that complaints a detailed description of what is happening, time, duration, and whether they have contacted the owner? I used to have a neighbor who would text me vague complaints days later, and then they would not respond when I asked follow-up questions. I was happy to address any issues, but could not get any information.
So in order to register a violation, and Marianne, feel free to jump in case I miss something. Detailed information is always requested. However, when so that kind of detail would be something that we would need in order to assess a violation. However, and certainly Marianne can attest that when we get a call from a neighbor, we really can't force them to tell us everything that they're concerned about. And while we try to ask as many details as possible, it's not always what the complainant is willing to disclose. So Marianne, am I right in that? I just want to make sure that I properly describe your experience.
You did a great job. You can have mine. No, that's right.
Next comment is from Jennifer Hagan. I want to thank you all for all the work you have done on this project. The draft proposal seems very reasonable.
Thank you.
Next question is from Dodie. How many complaints have you received in the past year?
Since 2020, we have received approximately 100. We have opened approximately 135 code enforcement cases, with the bulk of them being for lack of a short-term rental permit. In the past year, since 2020, we've received approximately 20 complaints, opened up 20 cases for lack of best efforts, which would be the loud parties, the disruptive people, things like that. Now, I want to let you know that I say we have opened up the cases. I want to differentiate, because sometimes code enforcement will receive 2 complaints from 2 different neighbors for the same incident that happened at one house. So within that one code case might be 2 complaints from 2 different neighbors, but we put all of them together. And it's because, again, I repeat, it is for the same incident.
And I would like to point out that the nature of that particular question would suggest that we don't have a significant problem, but I would like to point out that a significant number of people don't file a complaint with the city because the current process involves calling the owner of the property based upon the phone number that is on their permit. So we have kind of a system that is essentially designed for the neighbors to work it out with the property managers or property owners. And so the scope of the problem isn't necessarily identified by the number of complaints that we've received at the code enforcement department, Marianne's department. So, we have some people who have been living with short-term rentals nearby who are at wit's end, and we have heard from them recently. We have heard from them over the years, and that is what has caused this issue to be considered by the city council. It's time to update our ordinances and address some of the issues that neighbors of short-term rental units have been dealing with.
All right, the next question, how many of the 349 rentals have received a complaint?
Of the legal 349 rentals, how many, if I'm understanding, the question correctly, were brought into compliance after receiving a complaint. I would have to cross-reference our complaint list with the vacation rental listing, so I can certainly get that number for you.
But to her point, there's no question that there are, the bad apples, so to speak, and we're working to address those. I would like to acknowledge those people who have short-term rental permits that are that nobody ever complains about their properties, and we appreciate their efforts to be good neighbors and make sure that their property is not one of the ones that is causing the disturbances in these neighborhoods.
Next question is from Ann Bradford. If you have troublesome guests that is cited 4 nights in a week, can that lead to the revocation of your permit, or is it per guests?
If I could, Lillian, if you have a troublesome guest that's cited 4 nights in a week, as providing that they are verifiable separate incidents, it would be conceivably looked at for revocation. We would have to take a look at whether or not we can verify that, yes, in fact, Monday night there was a violation for lack of best efforts, Tuesday, lack of best efforts, Wednesday, lack of best efforts, because the code at this point does say that if you have 4 citations within a year, after the 4th citation, there's the possibility of revocation.
Next question is from Nayar Sadiq. Since STRs are businesses, how does city and city attorneys reconcile that there are businesses being inserted into residential zones?
So Roy, can you help me with this one?
Sure. So these are while they are considered short-term rentals, the Coastal Commission recognized that these uses are necessary in order to access coastal resources, especially our beaches. And in order to maximize those opportunities, that these uses have been considered ancillary or accessory to single-family and residential uses, which is how these uses are able to be permitted in residential zones. Particularly in our city, it's only permitted in single-family and duplexes. However, in other cities, STRs are permitted in all residential, including multifamily. So that would be my response to that. Next question is from an anonymous attendee. Can you please clarify that any complaints has to be filed by neighbors and not created by staff on quote unquote patrol of corridors?
So staff can note a violation if they observe it firsthand. Similarly, the sheriff can also note a violation in one of their reports in response to a complaint. So it's not just limited to neighbors. And Marianne, did you have anything to add to that? I just want to make sure my answer is comprehensive.
No, I think that's pretty comprehensive. It is, I can compare it to the patrols of the downtown area for the alcohol services staff. If we see something, it's verifiable, and we can go ahead and notify the property owner and open up a case and begin our case on that.
To clarify that, we're the only ones that can do the notice of violation are essentially deputized or trained in doing this. We don't have just random city staff in these corridors that can issue citations, correct? Marianne's she's code enforcement trained, and the pilot program will involve retired deputies is how we are envisioning this. So these are trained professionals and capable of going and testifying in court if necessary about what they've witnessed. And so.
Next question is from Tom Cousins. In the past, only properties classified as single-family residence in the tax record were allowed to be short-term rentals. Is that still the case?
Sorry, can you read that one more time, Roy?
Yes, in the past, only properties classified as single-family residence in the tax record were allowed to be short-term rentals. Is that still the case?
So I believe Roy provided an answer earlier, and I think the answer still stands, that duplexes as well as single-family homes can be included. And I think there are occasional areas such as Sea Bluff that are also included. I just want to be make sure that I have all of the scenarios.
Let's see, next comment is from Carolyn Winship. In my experience, owners can create more noise, more cars, and more trash. Next comment is from Wonderback Whiskey. Care needs to be taken if considering owner-occupied and non-owner-occupied rental homes. Owners often rent their homes when they're out of town or to supplement income by staying elsewhere with family or friends. Next comment is from Jennifer Hagan. I am in full agreement with the city collecting the TOT through the rental platforms. Next question is from Lizzie M. Is the recent video footage of the Malibu STR balcony collapse being taken into account as an illustration of the difficulties and dangers that come STRs along our bluffs?
I'm not familiar with that particular incident. If they would like to submit that to us, we're happy to take a look at that particular video.
Next question is from an anonymous attendee. What penalties do long-term rental owners pay if there are 3 noise violations in 24 months, or to homeowners who get 3 noise violations in 24 months?
So if it is a short-term vacation rental operator, under what is proposed, it would be revocation of that operational status. So revocation of any operations. With respect to residents, Marianne, how do we often work with residents?
The difference between a property that is being utilized as a short-term rental and a property that is being used by the homeowner with a family setting is a short-term rental is operated under a regulatory permit. They obtain money for getting this. That's why we have the regulations to ensure that it is neighborhood friendly. So to a homeowner who gets 3 noise violations, they get issued citations from the sheriff's department, but we don't revoke their homeowner status in 24 months. So I understand what the question is, but it's comparing short-term renters with homeowners. So, and again, the short-term rental comes under a regulatory permit.
Next question is from Randy Boyer. I was threatened by code enforcement for leaving my trash cans on the street. Not sure why enforcement of difficult rental units can't also be done.
Well, since I'm in code, I would like to apologize if you felt that you were threatened by code enforcement. What our typical notice is, we have a standard. You get your warning after we receive a complaint. You get your warning. If it's not brought into compliance, then you are told that there are different citation levels with the potential of having a citation fine. These are the same standards that we enforce on the difficult vacation rental unit.
Next question, where does the permit fee go?
So presently, the permit fees return to the general fund. Is that, and then with respect to the program fees that we're contemplating, and that would, I believe, as we are contemplating it, would be utilized for to ensure the administration of this program specifically.
The next question is from William Burton. What is the nature of the 24/7 contact number you referenced in your good neighbor policy? Does that refer to the owner's 24/7 contact number or a city representative?
So there is a requirement in the program and the ordinance as it currently stands that there is a 24/7 number that must be displayed for a point of contact to the property owner. Could be the property manager or somebody else that is administering the property. The goal for us would also be that we provide a city number under this new pilot program that could also be called to provide complaints in the event that the number that is available on site for the property owner, either his agent or operator, does not respond promptly.
The next question is from Susan Singer. Will the night weekend support staff be able to contact the owner at the time of complaint or witnessed violation?
If I could, Lillian, what potentially could happen is we could contact the sheriff's department. We make notes of it. But again, if there is a disturbance of the peace, the sheriff's department could also come out to additionally verify and come up with an event number.
Next question is from Cliff Keller. Will the city consider a no amplified outdoor sound rule for whole home rentals with no on-site hosts?
We can consider it. However, our noise ordinances apply to all homeowners, regardless of status. So, is that, Marianne? I'm assuming that I'm correct. I just want to make sure that I haven't misspoken.
Okay, what was that, Lillian?
So the question was a specific amplified noise ordinance for whole house rentals where the owner or operator is off-site. And I think that our noise ordinance applies regardless of status.
Right. I am finding that the hosts are requiring that amplified outdoor sound be turned off. They're doing that voluntarily. But right at this time, we only have our noise ordinance. And if it's extremely loud, once again, it's a disturbance of the peace and it's lack of best efforts.
Just to do a time check, Lillian, it's about 6:58, so I can continue with a few more questions.
Yes, if we could do one or two, and then I just want to reassure those that are participating today that we will be running a transcript of the questions that have been submitted. We will also be submitting and posting a report that responds to the questions to ensure that we respond to everyone that has taken the time to participate this evening, as well as posting both the slides at the request of one of the commentators and the recording. So yes, Roy, so one or two more questions, please.
The next question is from Carol Hink. I'm sorry, it wasn't clear. Can a condo in a 2-unit development still do STR? I can address that. Quick question is yes.
Do you want to do one more, Roy, and then?
Last question from an anonymous attendee. How is it fair to have higher penalties for breaking the code for noise parking complaints for short-term renters versus homeowners? Also, how abundant are complaints against short-term renters in the city?
So I think Marianne answered the second part of that question. And then with respect to the first part of the question, so what is anticipated is that we are going to have a pilot program that ensures that a permissive use, a regulatory permit, and those uses are appropriately being monitored and managed so that the residential neighbors in the area, are being respected with respect to those operations. I think Marianne did a great job of explaining that short-term rentals are an economic benefit. They provide, opportunities for visitors to come enjoy our city. But at the same time, we want to make sure that those visitors and that business use, that economic return is not potentially affecting the neighbors that have also made a significant investment in their homes and the opportunity to live in this community. So it is a balancing act. We are hoping to fairly implement modifications to our program that take into consideration both sides, but it's not anticipated that users and short-term rental operators that are doing so within the guidelines that we've set forth would have a problem. So, to the extent that you are an operator and you have, a renter that might be disrespectful, we just hold you to the expectation that you would recognize that your neighbors have expectations as well. So with that, I do want to express my sincere appreciation for everyone that has participated this evening. I know this is, again, a multi-sided, multi-perspective issue with many challenges. And we sincerely appreciate the feedback that we received tonight, and we will make sure that we respond to every comment that we received this evening, and certainly encourage anyone else to, should you have additional comments, to email aclisby@encinitasca.gov, and we will make sure to include that as part of our report. And with that, on behalf of city staff, I'd like to turn it over to Deputy Mayor Kranz and Councilmember Lyons for any closing words.
Yes, thank you. And I would like to echo the appreciation that was expressed in a couple of comments for the work that staff has done, gathering information and putting together the draft that we will be seeing at our city council meeting on this subject. And in closing, I would like to go back to that last question, which was what gives you the right to make the distinction between short-term renters and just your general lout that is causing problems in the neighborhood? The reality is that we have a code enforcement department because we deal with people who are property owners who aren't very good neighbors. It's not a very simple process, and establishing a nuisance has a whole slew of legal requirements that Marianne has been diligently pursuing for 30 years and is about to come to the end of her career and enter into retirement. Thank her for all of her efforts there. And that the reality is that a short-term vacation rental permit is a privilege, and that we are working really hard to balance the ability for a property owner to use their property the way they would like, while having their neighbors who live there on a regular basis can also enjoy the comfort of their home and the opportunity to live in peace. So we have permits, and we are working on addressing issues that would possibly cause us to revoke those permits, and that's perfectly within the police powers of the city. And we're here tonight, and we will be at the city council meeting in the future to hopefully come up with some solutions that will balance the issues that we've been talking about tonight. So again, thanks to staff and thanks to Joy for her efforts. And with that, you might have some closing comments as well, Joy.
Yes, I just wanted to say I appreciate all the public participation today. We had over 80 public members who invested a good amount of time in being present and listening and providing comments with over 110 comments. So I appreciate that everyone invested their time to help us synthesize all the input and improve, we hope, the quality of life in our city as well as our economic development. And it's always a juggle. It's always, trying to find the best way forward. So we appreciate everyone's input. I learned a lot from the public comment today. So I just want to say I appreciate that. And with that, I think, Lillian, you're ready to close?
Yes.
We're
Thank you.
adjourned. Thank you.
Thank you so much. Have a wonderful evening,
Good night.
everyone.